Hello, everyone. We apologize for the delay. We had a little bit of a technical problem, but I think we're up and live now. My name is Debbie Brenneman. I'm a partner in the Thompson Hine Labor and Employment Practice. I'd like to welcome you to today's webinar, and I'm fortunate to have with me today Matt Kissling, an associate also in our Labor and Employment group. From now until approximately 2, we will share our presentation regarding developments and guidance related to mandatory mandated closings. During the webinar, please feel free to use the question box typically located in the control panel to the right side of your screen to submit questions related to today's topics. We will answer some questions at the end of the webinar, and if we cannot get to all of them during our time together, we will make every effort to respond after the webinar. We are also going to be recording the webinar, and we'll send a link to all attendees after it is completed, likely sometime tomorrow afternoon. So let's get started with our topic for today. We're talking about workforce management considerations in the COVID-19 era. Sorry, one moment. And I'll turn it over to Matt to get started with our first topic.
Good afternoon, everybody. As Debbie indicated, my name is Matt Kissling. I'm an associate in our Labor and Employment Practice group based up in Cleveland. And the first topic we're going to review today is what do I need to know about my business operations in a government shutdown? I'm sure as you all have seen over the past week or so, especially accelerating the last 48 to 72 hours, a number of states and localities have issued either stay-at-home orders or essential business orders that are really cracking down on what businesses may stay open and what businesses must close in response to the COVID-19 pandemic. Currently, we have listed all the states that had these types of orders in place, starting with Ohio that was issued on Sunday afternoon, and then you have Indiana and Illinois, which are both nearly identical to Ohio's order. Pennsylvania, which was one of the first, issued last week. New York, which was actually the first. Michigan, that was issued yesterday. And then a number of other states that have really rolled out these kinds of orders in the last week or so. So really the question, here is, what you need to determine is, are you an essential business or are you a non-essential business? And if you're classified as an essential business under one of these orders, then you can generally maintain any normal business operations that are tied to something that's considered an essential activity in the particular state or locality at issue. And one of the issues we've seen that you really need to consider is where you have an operation that has both essential activities and non-essential activities occurring at the same facility. And really kind of the thing to keep in mind here is it possible to separate essential versus non-essential activities? If the answer is yes, then the majority of state orders would seem to require that you cease the non-essential activities, but you can then continue those essential components and utilize your employees accordingly. On the other hand, if the operations are really intertwined together and there's really no good way to separate them out, then the question becomes, do we have a really good faith basis or good faith argument for keeping everything up and running? And really, absent any concrete guidance from states or localities at this point in time, we've seen a lot of employers just continue to operate their full facilities until or unless a state authority tells them otherwise. So that's really one of the key questions here in making this determination is, are you an essential business? Do you have essential components? If the answer is yes, to what extent can you continue your operations? On the other hand, if you don't fall within one of those essential business categories, the majority of these orders require you to cease all normal business operations immediately. A lot of these orders, Ohio, Indiana, for example, do allow you to maintain certain minimum basic operations during a shutdown period, whether that's processing payroll or keeping IT functions up and running, as well as any basic operations that you need to enable your employees to be able to work from home on a daily basis. And for any of those activities that you consider to be a minimum basic operation, you are allowed to have certain members of your workforce come into the office or to the facility to make sure everything is kept up and running.
One question that we have had a lot from our clients in the last couple of days is, how does a government shutdown affect your employees' entitlement to many different types of benefits and leave? So we want to talk about those for a few moments. First of all, how does a government shutdown affect your employees' entitlement to PTO, to paid time off? Well, first of all, it's going to be important to examine your policy. There are no federal requirements outside of the Families First Coronavirus Response Act, which I'll talk about in a few minutes. There may be state requirements, there may be local requirements. We've seen, for instance, Colorado, New York, other states and localities enact paid time off requirements that may be applicable to a shutdown. And you need to consult, make sure you're consulting the laws of the state and the locality where you have employees, where your shutdowns exist. And of course, consider what flexibility you may want to have or to show to your employees during this difficult time. But absent, in general, employers can require the use of PTO when there are no other state or local requirements that say otherwise. Employees may very well, under your policy, be entitled to use that. But in such times as these, when shutdown operations may be necessary to reduce staff temporarily through furloughs or shutdowns or reduced operating policies, the Wage and Hour Division of the Department of Labor has indicated that forced use of PTO can be appropriate. The Department of Labor says since employers are not required under the FLSA to provide any vacation time to employees, there's no prohibition on an employer giving vacation time and later requiring that such vacation time be taken on specific days. So again, you're going to want to consult your policy. You're going to want to consult state and local leave requirements and work closely with your counsel in determining what may be appropriate and what you might want to do outside of what is required. With regard to the Federal Paid Leave Act, we have a lot of questions about whether a government shutdown affects the employee's entitlement to statutory leave. So that Paid Sick Leave Act takes effect on April 2nd. It's not effective yet. And under the language of the Act, the first bucket of entitlement indicates that employees may be entitled to leave when they are in isolation or quarantine due to a federal, state, or government shutdown. So one reading of that certainly could be, if they can't work, are they entitled to paid sick leave because they are in effect at home in isolation. However, CDC guidance defines isolation or quarantine as conditions impacting an individual. For instance, an individual has contracted the virus and is required to remain in isolation so as not to infect other people. Or an individual has been exposed and is quarantined or isolated so as not to contribute to the risk of further exposure. So using that reading, it seems that likely that the Federal Paid Leave Sick Act does not kick in for a government shutdown, but we are still awaiting some guidance from the Secretary of Labor on exactly what the parameters are, and we certainly hope to see some guidance on this specific issue so that employers can navigate this appropriately. How does a government shutdown affect your employees' entitlement to unemployment benefits? Are they eligible? What are the requirements? Well, again, you should look state by state where you have operations, but the Department of Labor has given states the flexibility to waive requirements and to make it easier for employees to obtain unemployment benefits. So in Ohio, for instance, workers would not qualify for unemployment benefits just because of the shutdown, but they will be qualified immediately if they're quarantined or isolated as a consequence of COVID-19. They would be eligible immediately if there is a layoff due to loss of production. They would be eligible if there is some reduction in operations, although that will impact the amount of claim that the employee might be able to obtain. For instance, any earnings over 20% of the weekly benefit amount would reduce their unemployment benefit payments dollar for dollar. So if you're considering some reduction in operations, reduction in hours, layoffs, and paid leave or unpaid leave, those are factors that you may want to consider in terms of how they impact your employees.
All right, so the next question that we're seeing is, how do I manage employee communications, if we're faced with changes in our requirements and operations? And really, it starts with transparency. This is a difficult time for everyone, for you as employers and for your employees and really everybody in this country. So it starts with just be honest and open in your communications. Obviously, there's been a lot of media coverage about these orders that go into place, and a lot of folks are aware that this may impact their employment. So if steps are necessary, whether it's a shutdown of your business or a reduction in hours or layoffs, it's important to just be open and honest with your employees. It's also important to really communicate often, whether it's providing weekly or daily updates to your staff on, what you anticipate may be happening or any changes or further developments that may impact how you're operating your business. Just stay on top of that with your employees to make sure that they understand, what their job expectations are during this period and how this may affect them as employees. You can also address common questions, to reduce rumors and potential misinformation amongst employees, such as a rumor that, a coworker was diagnosed with COVID-19, or that, large-scale lockdowns of your particular state or your particular city are going to occur. If you have information to show that these, in fact, are not true, it's important to address that, these concerns with your employees to make sure they understand, what the full picture is and what is actually going on. And another thing that's important to do is provide notifications, about any state or local requirements. So going back to what we discussed before about being essential or non-essential business, what we've seen a lot of companies doing is actually providing a written explanation for how a company has decided that it falls within an essential function that is permitted to stay open. The enforcement arm in a lot of these states and localities for these business closures is local and state law enforcement. We have seen some companies where employees did not understand why they were staying open and actually reported their organization to the police, and the police had to come in and address the issue and ultimately, make a determination. So you can really, cut that off at the beginning just by, again, being open and honest with your employees and providing them an explanation as to why your business is essential and is staying open and why they need to continue coming to work. And related to that, if you're in a state or locality with a stay-at-home order, we've also seen a lot of employers prepare what we're calling permission to work letters for employees. Where similar to the notification, it outlines your organization's essential status under the applicable law, and then explains that the employee with this letter is performing job duties related to that function, is therefore permitted to leave their home to drive to and from work on a daily basis. We typically see the employer providing some specific details as well as citing to the applicable order, so that law enforcement personnel who may pull an employee over and ask them why they're on the road will be able to see what particular part of the executive order or health order you as the employer is relying upon, and as well as how your employee is a key component to your essential business functions. And finally, what we've seen or recommend a lot are posting physical and digital notifications at your facility as well as on your website. And this is intended to, again, keep your employees informed. If you have other visitors such as suppliers or other essential businesses that are involved with your business and they arrive at your facility, they'll know at the outset why you're staying open and what essential function you're performing. And in the event that a law enforcement were to show up and question why your business is staying open, they'll also be faced walking in the door with a clear explanation of your business's essential function and why you're remaining in operation. And then again, going back to if you do have to make some changes or potentially face layoffs, it's important to convey that information about any changes or leaves that may impact your employees. So the first one is, will there be layoffs? This invokes a number of different federal and potentially state warn notice requirements, which we'll be touching on later on in this webinar. Are there going to be changes in work schedules? If you're reducing hours or asking employees to take an unpaid day off each week, that should be communicated in writing to those individuals. Similar to if you have exempt employees and you might be invoking a furlough, full week unpaid absence, that needs to be communicated to them in writing as well, so that they understand what they're being asked to do and how that again impacts their employment. Going back to a breakdown of essential versus non-essential functions, it's important to communicate to employees what will be operating and what won't be operating on a given basis. That may help you also determine which employees need to report into work and which don't. And then if you're considering any sort of voluntary unpaid leaves or requiring employees to use their PTO to cover any absences, again, this should be communicated to them in writing so that they understand what they're being asked to do and what's expected of them. So, and some additional considerations, if you're faced with actually having to reduce your operations or your workforce as a result of COVID-19, the first thing to consider is whether you're keeping employees or terminating them from employment. Some things to consider, would voluntary unpaid leaves be a possibility where you're keeping employees on your payroll, but they're just not working and aren't getting paid for a certain period of time? Another possibility to consider is, should we have reduction in hours or work schedules? Again, if you go this route, this is something that should be communicated clearly in writing to your employees, whether it's through email or company memorandum. Are you faced with temporary layoffs? If so, at this point, how long do you anticipate those layoffs occurring? Because again, this could, bring potential warn notifications into play. Another thing to consider is it going to be a permanent termination? Is this a situation where we don't anticipate our economic or our business conditions improving, in the near future? So, we need to permanently terminate some individuals or have a reduction in force. And then looking forward, if there are key employees, that you'd like to, stay with you, it is an employee retention bonus, something to consider where you have them sign an agreement, and if they remain with you, once business conditions get back to a normal level, if they're still willing to come back, they get paid some sort of a bonus. That could be a good way to, keep your key employees in the pipeline, even if you currently have to put them on an unpaid leave or on a temporary layoff. The other things to consider are from the benefits side. So if you keep employees on your payroll, the benefits coverage will typically continue. Obviously, this is subject to the specific terms of your benefit plan and what the plan requires. But some questions to look at are, how should employees pay their premiums? In a lot of business settings, we see employees pay their premiums through payroll deductions. Well, if they're on an unpaid leave of absence and aren't working and aren't getting paid, in that situation, how should they be paying their premiums? Is it cutting a check and sending it to the insurer, or are there other options that you can put into place so that employees can continue to stay current on their premiums and continue their coverage? You also have to consider the impact of reduced hours. Some health insurance plans, may set a floor on the number of hours an employee can work before their benefits coverage can lapse. So that's definitely something you need to be mindful of if you're considering reducing the hours of certain employees on your workforce. On the other side of the coin, if you're faced with a layoff or a termination, this is where potential COBRA continuation is going to come into play, as well as providing the necessary notices to any terminated or laid off employees of their options to continue their coverage under COBRA, as well as what their obligations and payment requirements are and to keep that coverage. If you fail to provide this COBRA notification in a timely manner, please note that there are some pretty significant penalties that you could face if you do not provide the COBRA notice to your employees. The other thing to consider, if you're deciding to reduce operations, are the impact of state final paycheck laws, where if you terminate somebody, this could invoke requirements to pay final wages and other forms of compensation to employees that are leaving your payroll. This does tend to vary based on the state that you're in, whether it's in terms of timing of the final wages, as well as if you have commissions or bonuses, when are those forms of compensation considered to be wages, and if they are considered wages, when must they be paid? And then another thing to look at is if you have unused vacation or PTO, some states like California treat vacation as provided as wages that must be included in any sort of a final paycheck. So this is a hot button state law issue that's again coming into play with the COVID-19 pandemic and any reductions or layoffs that go along with that. And another area to consider are if you have to let people go, is it possible to have some form of separation agreements for folks, as well as what's the impact of employees who have existing employment agreements? So if you want to go the separation agreement route, this could be a good opportunity to provide some sort of severance in exchange for release of claims. You do need to consider what's the impact of severance on an individual's unemployment eligibility, which does depend on the state in which you're operating, where those employees are located. If you have an existing employment agreement with your employees, how does a reduction or a layoff apply to potential separation pay obligations under that employment agreement? If you have an agreement that only has a for-cause termination provision, and if you terminate someone for anything other than that cause, including a layoff due to COVID-19, that could trigger a potential severance or separation pay obligations to those individuals. Another thing to think about is how does this impact restrictive covenants that you have with your employees, confidentiality, non-solicitation, or non-competition. A key thing to remember here is those covenants should continue in force even if you have a layoff due to the pandemic. And this is something that we've seen employers remind their staff in writing of their continuing obligations in the event of a layoff. And finally, if you have agreements for bonuses or advances or loans to employees, what are the repayment obligations to those individuals, or for those individuals, and could they be impacted or modified due to the COVID-19 layoffs? A good example is if you provide someone a signing bonus, and if they leave your payroll at any point within 12 months, they may have to pay back all or a portion of that. Something to consider is whether or not to have a new employee just being let go because of the pandemic and the reduction in operations. Is that still something you want to hold them to, since this is really a situation that's outside of your control? So, those are all things that you should be considering when it comes to agreements with your employees. The next area they need to consider is in the wonderful world of unemployment compensation. Next slide, please. Thank you. And here, you could be faced with, depending on the reason for a layoff, you could be faced with a flood of unemployment claims. We've seen a lot of states take action that say, if someone's unemployed because they're under quarantine or isolation for any other reason related to COVID-19, their states are waiving the eligibility periods or the waiting periods, and are essentially permitting all those impacted employees to obtain unemployment compensation. So this is a situation where you could be faced with a flood of these claims coming in the door. The next question you need to consider, what's going to be the impact on your insurance rating or your premiums? Again, this depends on what's the specific reason that an employee is let go. We've seen some states that'll say any COVID-19 separations aren't going to have an impact on your ratings, because this is really something that's outside of your control as an employer. But there are other states that aren't taking that approach. So it's really a state-by-state determination. This is something that you may want to examine with your third-party administrator or claims adjuster to determine what any impact these floods of unemployment claims are going to have on us as a business. Another thing to think about is, difference between total unemployment and partial unemployment. So if you lay somebody off or permanently separate them, they're most likely going to be able to obtain total unemployment benefits. At the same time, the thing to keep in mind is if you reduce work schedules to a certain level or put somebody on an unpaid furlough, they could still obtain unemployment benefits under a particular state law. So even if they're still on your payroll and they're on a temporary unpaid leave of absence, they may still qualify for unemployment benefits. And again, that could have an impact on your insurance premiums, depending on the state that you're dealing with. And finally, there are certain state specific notices that you need to consider, whether it's from a layoff perspective or any other sort of termination of employment. A good example is Ohio and the state of Georgia both have mass layoff notification requirements where you need to notify the relevant state agency of the individuals that you're laying off, so that then they can essentially kickstart the protective measures and potentially the unemployment process for those individuals. Oh, and so the next thing that you need to consider is the difference if you're looking at changes in operations. What's the difference between a furlough and a layoff, and what do I need to consider in putting this into place? So furlough is different because, again, you're essentially keeping your employees on payroll, but you're putting them into an inactive leave of absence status. So this typically can involve a reduction hours or a mandatory unpaid leave as opposed to permanently or actually terminating the employment relationship. The advantage of a furlough is that it does help to retain talent, and it can also reduce potential costs of separation, such as final paycheck requirements or paying out of unused vacation. It can also reduce any costs down the road when you're ready to bring people back. You could avoid the process of having to go through the hiring process again to refill individuals, as well as expending the capital and the investment on training new employees, bring them up to speed on your business and your operations. So there are definitely a lot of advantages with furlough, but there are a few key considerations that they need to have. And the first revolves around the FLSA, as well as state wage payment laws, where if you're putting someone on a reduced work schedule, if you're requiring them to take an unpaid leave, this could impact their status as an exempt employee under the FLSA. It's much simpler if you're dealing with hourly non-exempt employees, where you can ask them to only work 4 days a week and reduce their hours to 32, and then they're still only going to be getting paid for the time that they actually work. Where it gets complicated is if you have an exempt employee, where under the FLSA, they need to be paid the same salary regardless of the amount of time that they work for any work week in which they actually perform work. So for exempt employees, you really can't ask them to take, one unpaid day per week. Instead of furlough for them would need to, essentially be an entire week where they're not working and they're not getting paid. It needs to be all or nothing, at least an increment of 1 week. It can't be a partial week for exempt employees. Otherwise, you're going to be, facing waiving the exemption status for those individuals, which then could trigger a number of other issues from overtime, hours tracking, and wage payment perspectives. Again, the other thing you need to consider are employment agreements, which we touched on before. And putting someone on an unpaid furlough, if they have an employment agreement, what impact is that going to have? Is that going to trigger any sort of separation pay requirements, or is that a situation where they could terminate their employment voluntarily and then get separation pay out of you? So that's something you need to keep in mind if you're thinking about putting folks on an unpaid furlough for a period of time. Again, notifications to employees, it's important to be clear and open in communicating these types of changes to your employees. And this could also make it clear to them what their obligations are, what the expectations are, and potentially how long is this furlough is going to remain in place. Another consideration is, again, benefits coverage. Some plans may say if you put someone on an unpaid leave status for a certain period of time, benefits coverage may drop, which then you'd be faced with a situation where you may need to potentially provide them federal or state COBRA notification for continuation of benefits. And finally, as I mentioned before, this could also have an impact on unemployment eligibility, where even if they're still on your payroll and they're being furloughed or their hours are being reduced, they could still be entitled to recover or receive unemployment benefits, depending on the state that you're working in.
What about other options besides furloughs or layoffs that can help decrease employment-related costs, at least in the short term? One thing that employers might look at is a reduction in hours. That can be beneficial, but there are a lot of things to consider. First of all, if you have a collective bargaining agreement, that may well govern issues relating to your ability to reduce hours. Outside of a union environment, there are other things to consider. As Matt was saying, if you have an exempt employee, they are required to be paid for any week in which they perform services for you. So a simple reduction in hours by itself for an exempt employee is really not going to reduce your costs in any way. It can be effective with regard to non-exempt employees. You're not required to pay non-exempt employees for hours that they don't work, but you do have to consider such issues as what impact it may have on health insurance. Are you keeping above the 30-hour threshold? And any impact on the potential unemployment benefits. As we said, states have minimum requirements. If employees are earning more than a certain threshold, then their benefits are going to be lessened or reduced by that. There are also issues to consider with regard to non-exempt employees that you may need to retain on some kind of on-call basis, not necessarily on premises, but maybe close by. So on-call is not triggered, though, if you are merely asking a non-exempt employee who's out on an unpaid leave of absence to provide his or her contact information in case you need to reach them. So reduced hours are something that you can consider, but certainly you do have some things on the checklist to think through before you might do that. Other employers are asking about what about reductions in salaries and compensation to employees. Once again, there are a number of things that have to be reviewed with regard to your ability to do that. First, certainly if you have any employment agreements, they may be binding on the amount that you're able to, that you are obligated to pay to an exempt employee. There are other limitations specifically with regard to exempt employees. The Department of Labor does allow you to prospectively reduce a salary amount paid to an exempt employee, specifically during a business or economic slowdown, but you have to be able to show that that's bona fide and not just used as a device to evade salary requirements. So certainly you're going to have to keep the salary above the minimum threshold on the salary basis of $684 a week. And the Department of Labor also frowns on really short-term reductions in salary. So if you are trying to make day-to-day or week-to-week determinations based upon your operating requirements, that's probably going to destroy exempt status. The Department of Labor is going to look at whether you're making long-term decisions about your long-term business needs. In this situation, that may not be what does the next 2 years look like. It might be what do we expect over the next 6 to 9 months, but you have to make some rational determinations. As Matt mentioned, you may very well have some state notice requirements. Generally speaking, if you are going to have a reduction in pay, you will have to make sure you are informing individuals that on a go-forward basis, this is what you will be paying them. Certainly with regard to work that's previously been performed, you have to pay the agreed upon or the previously set rate of pay. Before reducing compensation or salaries, you do have to consider non-legal issues like how is this going to impact your employee morale? What long-term effect will this have, and will it lead to departures of employees that you don't want to lose in this critical time? Other options that you can consider are voluntary staycations. If employees want to volunteer to take time off. With regard to exempt employees, if you offer a voluntary plan to take unpaid leave, if they are taking it for personal reasons, then you may be able to reduce their pay on full-time increments. You can consider something like an early retirement program if you think that this necessitates a reduction in your workforce, and an early retirement program might be a way to get, to achieve your goals. But there are a lot of legal risks and requirements in doing that. You are going to need to determine an eligibility group. You have to consider your business objectives. What are you trying to achieve? What criteria do you want to set? And certainly with regard to any of these programs, you want to make sure that you are if it's a reduction in hours, if it's a reduction in pay, if it's an opportunity for voluntary unpaid leave or early retirement programs, you really need to make sure that you're consulting with counsel and approaching these in an objective way. You don't want to be accused later that you are only choosing certain categories or protected classifications of employees when you're making these decisions. So it's very important that you work closely with counsel in developing these different options. Another opportunity that may be out there for you is some change in benefits. And again, you'll want to work closely with your benefits counsel, but it may be that you can eliminate your 401k match if you have a matching program that's going to be dependent upon your policy, certain legal requirements, and again, something you're going to want to work very closely with counsel in arranging. And Matt is going to talk a little bit about if layoffs are necessary and whether the WARN Act might be triggered.
Right. So, this is the question: is if you are looking at terminations or layoffs as being necessary, what sort of notification requirements do you need to consider? And this really starts with the Federal WARN Act, where it generally, applies to any businesses with at least 100 full-time employees, or if you want to go outside of full-time, it can also apply to any business with at least 100 employees, both full-time and part-time, as long as those total employees together work at least 4,000 hours per week, not including overtime. And what the WARN Act requires is at least 60 days written advance notice of any plant closing or mass layoff, as those terms are defined in the law, which we'll touch upon in a moment. The important thing to remember here is that the notice requirements, and including determining whether notice is necessary, is on a location by location basis. You're not looking at necessarily your company as a whole in deciding whether notice is necessary. Instead, you're looking at, okay, it's location A, I'm laying off X number of employees there, is more notice can be required. And then you do a separate determination for location B. So again, notice is on a location by location basis. The number of impacted employees is key for determining whether notice is required. This kind of goes back into the definition of a mass layoff, which we'll be touching upon. And the key thing to remember here again is, so deciding whether you're covered as an employer as well as notice is necessary, you only should count generally full-time employees in making that determination. With that said, if you have both full-time and part-time, and your full-time employees, the number impacted brings you within WARN, and you would still need to provide notice both to the full-time employees and to the part-time employees at issue. So, the first kind of critical question, in determining WARN coverage is, what exactly is an employment site? This is typically an individual company facility, so, a production plant or your headquarters office. It could also be a series of separate buildings on the same campus. So if you have a corporate campus, where you have several separate buildings, but employees tend to go back and forth, between those buildings, the buildings are interconnected, that entire campus is going to be considered a single site of employment. Another possibility is that, buildings in close proximity to each other geographically. So, if they're located across the street or within a mile or so of each other, within a town, they could also be considered a single site and share resources, equipment, or employees. Next slide, please. So after making that decision on
Matt, if I could interrupt you for one moment. We seem to have a lot of interference with audio. If anyone who's not speaking could please make sure they are on mute, it'll be helpful. Thanks, Matt.
Sure. And sorry about that, everybody. So, okay, so we talked about employment site. So the next question is, what is an employment loss? And generally speaking, WARN considers three different scenarios to be an employment loss. The first is if an employee is involuntarily terminated for a reason other than for cause. So, someone being terminated due to, reduction in business because of COVID would be considered an involuntary termination without cause for WARN purposes. This also does not include retirements or resignations. The second type of employment loss is if an employee is laid off for more than a 6-month period of time, which can come into play, and we expect this will come into play, with the current pandemic. Third is, this could be triggered under a furlough situation where if employees' hours are reduced by at least 50% in each month over a 6-month consecutive period. So you look at a period of 6 consecutive months, and each month your employees' hours were reduced by at least 50%. Any of these scenarios are going to be considered an employment loss that could then potentially trigger WARN. So, how exactly are you supposed to count employees, when making these determinations? And again, I mentioned before that you want to look at full-time employees who are being impacted, by your current, COVID-19 layoff if you're considering one. Another thing to remember is you actually, in certain situations, do need to look both behind and ahead 90 days, for making that count. So, are there any other COVID-19 layoffs that have occurred in the last 90 days or that are planned in the coming 90 days? Now, you see the 3 aspects here. It's important to note that, under this 90-day look ahead, look behind rule, it really only kicks in if each of your layoffs during that period by themselves would not be enough to trigger WARN. If you have a single layoff event, so let's say, in the current situation, you're going to lay off, 100 full-time employees, and that represents about 50% of your workforce, that layoff alone is going to be enough to trigger WARN. So that you wouldn't combine that with another layoff 90 days down the road to decide whether notice is required for that layoff as well. And another question to ask is, how long are the layoffs currently expected to last? You remember from the prior slide, a layoff's only going to be considered an employment loss if it lasts longer than 6 months. So currently, if you're considering a layoff that is going to go through, let's say in Ohio, currently April 6th, which is the current expiration date of the stay-at-home order, that's obviously not a 6-month period. So that may be a situation where you would have a layoff, but you would not need to provide notification under federal WARN. The thing to consider there is if the governor extends the stay-at-home order and the business closures, past April 6th, and it continues for a prolonged period of time, and you're creeping closer to, that 6-month duration, then you're going to be faced with a situation of potentially having to provide the notification. Some common questions that that we're seeing in this layoff situation is first, I don't know how long the layoffs will last. Will provide WARN notice. This kind of touches upon what I mentioned before. It's really up to you. The safest approach is the conservative approach. Where you provide a conditional WARN notification to employees, where you basically say, we expect these layoffs to be temporary, but we're going, and we don't necessarily expect them to last 6 months, but we're going to provide you the notice anyway. The next question is, I need to conduct layoffs now. Do I still need to wait 60 days? Here, the federal WARN actually has certain exceptions to that 60-day notice requirement. One of which is what we call the unforeseeable business circumstances exception, where basically at the present day, if you need to conduct layoffs or shut down operations due to circumstances that were not reasonably foreseeable 60 days ago, then your obligation here would be you just need to provide the notification as soon as possible. It could even be on the same day as the layoff taking place, or if you're planning them for next week, providing it sometime this week. So that is an exception, and our belief at this point is that the unexpected development of COVID-19, as well as these rapidly expanding state closure orders, would likely fall under the unforeseeable business circumstances exception. And so you wouldn't need to wait 60 days to provide that notice as long as you do so promptly, in conjunction with a pending layoff. And the last question, that we typically see is, okay, we've talked about federal warn. Is there anything else that we need to worry about here? And really the answer here is yes, that a number of states do have their own warn notice as well as layoff notification requirements. We've listed out, based on our review, all the states that currently have some sort of a requirement on the books. And I'll mention that not all these states have things identical to the federal warn. They really vary in terms of of what they require. And some examples here are New York, which is pretty close to what federal warn requires, but they have a lower threshold for triggering. So one thing to note about federal warn is that a mass layoff is something that impacts at least 50 full-time employees at a single site, and that those at least 50 employees represent at least 33% of your full-time workforce at that particular location. So New York has a lower threshold for triggering, where you only need to impact 25 employees as long as those 25 employees, full-time employees, represent at least 33% of your workforce. So California has a similar warn law in place. It's interesting to note that in Governor Newsom's slate of executive orders that he issued last week in conjunction with their stay-at-home requirements, he actually suspended California's state warn requirements during the epidemic, with the caveat that you don't have to provide California warn as long as you follow the federal requirements for providing notice under the unforeseeable business circumstances exception. So they're basically telling you, we consider this epidemic to be an unforeseeable business circumstance. As long as you do what you need to do under federal warn, you don't need to follow our state's requirements. So if you have operations in California, that's a pretty helpful thing to have. In that situation, you really just need to focus on meeting your obligations under federal law. And then you're kind of at the low end of the requirements are Georgia and Ohio, where they don't really have any specific notice requirements they need to give to employees, but they do have particular layoff notifications that need to be provided to the state agencies. So in Georgia, it's the Georgia Department of Labor, and then here in Ohio, it's the Ohio Department of Job and Family Services, where it's basically you need to provide a notification as how many employees you're laying off, as well as some additional information that then those states can use, most likely to trigger any unemployment assistance that they may be able to provide, as well as to just keep them on record.
So as we turn to some of the other top questions employers are facing in managing their workforce right now, we have just been given some additional guidance from the EEOC on a couple of other important questions, such as what can you ask your employees about their health and their exposure in an effort to minimize spread. So until just a couple of days ago, the EEOC had sort of republished its guidance from 2009 related to the H1N1 virus, and suggested that employers could follow the recommendations of the CDC. But just in the last couple of days, the EEOC has officially updated that guidance to address the COVID-19 pandemic and answer some questions that we really have been getting about what can you do with regard to employees who present in the workplace with symptoms, about questions that you may ask to employees and prospective employees. And the EEOC guidance really has increased employers' flexibility. So, for instance, the EEOC has now officially embraced the CDC guidance, saying that an employer can send home an employee with COVID-19 or with symptoms associated with it. You don't have to wait for a diagnosis. You don't have to wait for a positive test. If they're presenting with symptoms, you can and you should send them home. The EEOC has also confirmed that it adopts the CDC guidance that you may ask employees who report that they're not feeling well or who call in sick, you can ask questions to determine if they may have COVID-19 related symptoms like fever, chills, cough, shortness of breath, sore throat. Certainly not everyone who has COVID-19 has those symptoms, but those are the symptoms that may be associated with it. The EEOC has also embraced a position that the governor took a few days ago, that you now do have the ability to monitor employees' temperatures. So you can take employees' temperatures when they report to work every day. Just because you have that ability doesn't mean that it doesn't come without some practicalities that may be difficult. Are you going to have your employees line up? How is that going to impede an employee's ability to get into the office or to get into the site, do their work? And what about the information that you derive from that? Certainly if there's the fact that an employee has a fever or other symptoms, would be subject to ADA confidentiality requirements. So you don't want everybody all assembled in a line and everybody seeing what each other's temperatures are. So you need to think through, if you feel like you need to do that, you need to think through what is an appropriate way to do that. Question often comes up during a pandemic such as this: can an ADA-covered employer ask employees who do not have symptoms, can they ask them to disclose whether they have a medical condition that the CDC says can make them especially vulnerable to the complications relating to the virus? And what the EEOC has not really changed that guidance, but re-emphasizes that where there is a pandemic, ADA-covered employers might have sufficient objective information from public health advisories to reasonably conclude that employees may face a direct threat if they contract pandemic influenza. So in that instance, they may be able to make disability-related inquiries or require medical examinations of asymptomatic employees to identify those at higher risk of complications. And we'll talk about in a moment what might be appropriate accommodations for those types of employees. So this now becomes a direct threat analysis. And again, you're going to want to work closely with your counsel in navigating through that. Other things that the EEOC emphasizes is that you can encourage or require employees to work from home. You can require employees to adopt your infection control practices, like regular hand washing. You may require your employees to wear personal protective equipment to reduce the transmission of pandemic. So if that's practical, you can do that. You will still need to accommodate, for instance, if you're requiring employees to wear protective equipment, if there is an employee who has a disability-related needs, such as an allergy to latex, you may need to provide non-latex gloves. So you still need to think through your accommodations. But this really does give you some more flexibility in taking steps to help minimize spread in the workplace. There are also some specific guidance with respect to your hiring process during the COVID-19 pandemic. The EEOC has indicated that if you are hiring, and many establishments are due to increased needs, an employer may screen applicants for symptoms of COVID-19, as long as it does so for all employees in that same type of job. So again, consistency is absolutely key. An employer may actually take an applicant's temperature as part of a post-offer pre-employment medical exam. And an employer may actually delay the start date of an applicant who has COVID-19 or who has symptoms related to COVID-19. One very interesting guidance from the EEOC has to do with whether you can withdraw a job offer if the applicant has COVID-19 or symptoms of it. Well, the EEOC says if you have an immediate need for that applicant to start, and they cannot do so due to the fact that they have COVID-19 or symptoms, you can withdraw the offer after it has been made in those circumstances. Another area that the EEOC has clarified with regard to this new pandemic guidance is some ways to handle reasonable accommodations. So it continues to be that there aren't accommodations or any leave that's available just because an employee may be fearful of contracting the infection. So if you have a healthy employee, they don't indicate that there are any heightened risk factors. They just are afraid if they come to the workplace, they may have an increased risk of exposure to COVID-19. they are not going to fall within the ADA. They don't fall within current federal leave requirements if you're an employer of 500 or fewer employees. You may want to provide accommodations just because you feel that's the appropriate thing to do. You may want to offer unpaid leave, for instance, especially if you're facing some economically troubled times, and it would lighten your load to have the employee go on unpaid leave, but that's a business decision for you to make. With regard to accommodations for high-risk employees, as I just noted, the EEOC has said that you may obtain objective evidence that would suggest that employees in high-risk categories might be particularly susceptible. And you can talk to them about placing them on some kind of leave, providing them with telework, making some arrangements to accommodate them in that particular situation. What you need to also bear in mind is that the EEOC is mindful that you have other employees who have non-COVID-19 related accommodation needs. And the EEOC does state you need to continue to work on these accommodations to engage in the interactive process, but recognizes that this might be a time where you have to rely on short-term solutions before you come to a long-term one, or that some accommodations may be delayed. The important point is that you're going to be continuing to engage in that interactive process with employees for non-virus related accommodation needs, and make sure you keep those discussions going. So with that, we'll now begin the question and answer session. We'll address some of the questions that were submitted in the time remaining related to the topics that we've been speaking about today. And after the webinar, we will have some other instructions for additional questions that you may have. But Matt, I'll turn it back to you. Do you want to take one of the questions that have come in?
Sure, yes. One of the questions that came in earlier today was, are the permission to work letters that we mentioned necessary? And really the answer there, it really depends on the state that you're in. We've seen some states such as Illinois or even in Ohio, where it's been suggested that law enforcement may not necessarily pull people over just for being out on the road. So there might be a low likelihood that that you would actually need one of those letters in place. On the flip side, we've seen guidance in Pennsylvania that they're taking a much stricter approach and are actively employing law enforcement personnel to enforce the governor's business closure order, as well as the stay-at-home orders that have been issued for certain counties in Pennsylvania, where they really want people to stay inside. So, in the answer to that question, it really depends on the state. With that said, the letters do serve kind of a dual purpose. First, they can help protect your employees in the event that they do get pulled over, and they also serve as an educational function for your employees, as well as any potential law enforcement personnel, as to the specific exemptions that you believe your business falls under as an essential or a life-sustaining business and is permitted to stay open. So it's something that's not necessarily required, but it is something to give consideration to, in terms of keeping open communication, as well as protecting your business and protecting your employees.
Thanks, Ben. And I will also note that I have seen instances where employers who work with other staffing agencies or temp agencies, the affiliated companies are requiring that they have these types of letters for their employees as well. So we've seen that come up. A couple of questions related to the Families First Act that I'll just touch on briefly. There's a question about whether employers over 500 full-time employees face obligations under the new regulations, and the act as written does not pertain to employers who have more than 500 employees. It is written to apply to those who have 500 employees or fewer, with some exceptions for employers who have less than 50 employees. Another question in that regard is, are people eligible for emergency sick and emergency FMLA leave if they are home but are able to work remotely? It is important that both the Paid Sick Leave Act and the expanded FMLA Act, which relates only to the closure of schools, daycares, and child care providers, the Leave Act, they both specifically state that they apply if the employee is unable to work or telework. So if the employee would otherwise be qualified for leave, but they are able to work from home, then it would appear from the text of the Act that they would not be eligible for the leave. Matt, you want to take another one?
Sure. There was another question that came up when we were talking about providing a written notification to employees, for a number of different reasons, whether it's for reduction in hours or layoffs, stuff like that, as well as kind of the your company's designation as an essential business. One of the questions was, is there any specific mode of writing that's required? Could it be in a text message or a similar electronic communication? And generally speaking, we would probably advise against making any of these communications via text message or WhatsApp or something like that. Instead, it's our recommendation would be to at least do it from a company email address, or if your employees don't have company emails, then issuing a written memorandum or letter to them, just notifying them of whatever the necessary issue or changes.
Next question is, have we received guidance from the DOL yet regarding how a business can apply for an exemption from under the new legislation regarding paid sick leave and FMLA? We have not yet received that type of guidance. We are still awaiting it. I will note that the Act does reference 50 or fewer employees, and where the payment of the benefits would basically compromise the business's viability. But we are awaiting those regulations. We are also awaiting regulations that provide further clarification on how pay is calculated and how the Act plays out in general. So we were hopeful to have those pretty quickly, but we're getting ever closer to the effective date. Certainly we'll have them beforehand, but how much beforehand, none of us can really predict at this point. Matt?
Sure. Yeah, another question, centered around WARN notification, where let's say you're a company that has a number of different individual job sites, that your employees travel to. Would that be considered an employment location for WARN purposes? Yeah, at this point, our guidance is that would most likely be considered an individual employment site. So if you shut down operations at a particular job site, and lay everybody off, then that's a situation that could trigger the WARN notifications. Again, that depends on the number of employees that you have working at that particular job site.
Thanks, Matt. Next question, if you do a furlough or layoff before April 2nd, would the employer still have to provide emergency sick leave or FMLA leave? There are no retroactive provisions in the Act, so it appears that while certainly you could provide paid leave before it takes effect on April 2nd, if the employee qualifies for leave on or after April 2nd, they would still be qualified for that leave. And importantly, if you provide paid leave ahead of time, and again, certainly your prerogative to do, and your employees will be very appreciative of it, it does not appear that you would be eligible for the tax credits that are available for the leave that's specifically contemplated under the Act itself. Matt?
Sure. Yeah, another question that came in is, asks if dealing with exempt employees, is one solution to address reductions in operations, issuing a new offer letter with a new required effort time like 80% with a corresponding salary. That's certainly one way to go about a salary reduction for an exempt employee, is if you're reducing them to less than 100% or less than full time, and then essentially prorating their salary. As long as the salary reduction is a fixed amount and continues, and is not it doesn't depend on the week in which they're working, that's certainly a way you could go about it. And that's not a situation that's necessarily limited to this COVID-19 situation. We've seen some employers who have kind of those less than full-time arrangements, with employees who transition from 100% full-time down to 80 or 60 or 70%, and their salaries prorated moving forward in connection with that reduction.
Thanks, Matt. I think time for one more question. I'll just say that I've seen a lot of questions come through about the leave entitlements and whether they are in addition to any benefits that the employer may currently provide. And the answer to that is yes, these benefits are in addition to that. And again, you cannot require, if you fall within the confines of the Act, if you have fewer than 500 employees, you cannot require your employees to take other paid leave in place of or before they take the leave that's provided to them under the Act. Last question, our employees are all working remotely and offices are closed. Everyone has access. Are they still eligible for emergency FMLA and or emergency sick leave under the Families First Act? As I stated a little bit earlier, no. To the extent that the employees are able to continue to telework, then paid leave under these provisions would not kick in. And just to underscore, with regard to the emergency FMLA, that expanded leave act, those particular provisions are relevant only to employees who must stay home to care for a son or daughter under the age of 18 whose school, child care, or compensated child care provider is unavailable due to COVID-19 considerations. So Matt and I thank you again for being with us today. If you have additional questions after today's webinar, please email or call your regular Thompson Hine lawyer, and they will direct you to a member of our COVID-19 task force, which is a multi-functional task force covering all of our practice groups. If you're not a current Thompson Hine client, please contact one of us and we can discuss with you options to address your needs. We certainly thank you for joining us today. And if you submitted a question via the chat feature that was not answered today, someone will follow up with you via email. Thanks again, and best of luck to everybody.